When you pass along resources to the next generation, your hope and desire is that they will manage them well. While it's impossible to completely control resources from beyond the grave, you can take steps to protect your children's inheritance from creditors, especially if your children have shown an interest in investing in their friend's llama farm or have shown questionable judgment when operating motorized vehicles.
So, llama farm, Spencer, have you or your kids really been approached about investing in a friend's llama farm? And if so, how does this come up when we think about protecting an inheritance from creditors?
Well, I've not been approached, but I'm guessing that at least one of my children has been approached with something like this, and particularly one of my kids, so would be really interested in this. Yes. So it is something that's always interesting. You build relationships in life, and sometimes if you don't have great judgment, you can make significant mistakes that can put you on the hook for far more than you even realize, because most of us are not attorneys and we don't necessarily think within what we can lose if we become a partner within some particular venture.
Yeah. Okay, so let's back up here in just a little bit and say, today we want to really be focusing on how do we get questions from clients of, okay, if I pass resources along to the next generation, what is at stake for them? What's liable for them? And so really the conversation we want to have is, how do you think about passing along resources wisely to the next generation so that maybe there's a little bit of protection therein? So what are some of the key things that clients need to know, that viewers need to know about protecting an inheritance from creditors?
Well, first you need to know that even though your IRA, your 401k is typically protected from creditors, not always, but in most circumstances, for instance, if you save towards a 401k, you roll those resources over to a traditional IRA, there is creditor protection, generally speaking, there. If you pass those resources on to the next generation, probably not. The courts have not definitively ruled on this, but some of the rulings have shown that the courts do not hold those traditional IRA resources that are inherited IRA resources to the same standard that, say, a participant would have. So if your son or daughter received those resources, and let's just say, heaven forbid, something happened to them on the interstate, got in a wreck, were held liable, those resources could be included in a judgment against them that a creditor could seize, theoretically there. Whereas it's our understanding, and again, we're not attorneys here, but it's our understanding that that would not be the case in the vast majority of circumstances with your own retirement resources that you've saved, say, through a 401k type of arrangement. So with that, what we need to understand is most of those resources that you're passing on to the next generation, they're not going to have creditor protection unless they're put into a trust with specific provisions in that trust that will protect them. So there's always a trade-off. The trust, generally speaking, is going to have a little bit higher cost to it. Sometimes there's even administration costs to that trust on an ongoing basis. But there is some creditor protection there. So a lot of our clients who have a high level of confidence in their children and passing those resources on, they don't put resources in a trust. They look at that trade-off and say, that's not one that I want to take advantage of. There are other clients who look at the decisions that their children or their grandchildren are making and say, oh, I'd like to have a little more creditor protection, so let's put those assets within the context of a trust.
Right. Okay. So let's talk about, what do we mean by creditors? Sometimes when we think creditors, you just hear a bank or that person that calls you and says, hey, you're behind on your credit card. I need to come get that payment. What is a creditor? Yeah. How do we actually think about this wisely?
Well, it's really anyone that a person owes money to. Now, you highlighted that oftentimes we would think about a credit card company, or we would think about a bank. There, if we have borrowed money, say on a home loan, or if we've borrowed money through credit card, those would be very typical. But those are oftentimes not what's going to get a child or grandchild in the most trouble. Yeah. A creditor who would have a much higher potential capacity to come after you for funds might be one that, if you're a partner in a business and your business does things that harm people and you are on the hook as a partner of that, you could be in trouble there. if you're out on the interstate and you get into a multi-vehicle crash, and let's just say you have really thin insurance on that, but you have lots of assets behind that, that could be, a significant problem. Or let's just say that you didn't even know you necessarily had all those assets. You just had someone pass away, and those resources are coming towards you. They essentially are going to be yours, and now you're in trouble there because you've got lots of assets. You have very thin insurance. So there are ways that we can go back to that first set of trade-offs and say, well, if you have a really strong umbrella insurance policy, for instance, and if your son or daughter does, who's inheriting those funds, has a really strong umbrella insurance policy, let's just say that they're not prone to getting involved in setting up a company that would be they would be on the hook for certain expenses or liabilities, then a trust might not be as important. But for any of those other reasons, the creditors, it's not just a credit card company, it's not just your bank, it's any really poor financial decision that could have an exponential impact on your heir.
Yeah. Okay, so let's talk about, you touched on trust a little bit. Let's talk this idea, the difference between a revocable and an irrevocable trust in terms of the different protections and how we should think about whether resources go to revocable or irrevocable.
Well, so oftentimes you'd set up a revocable trust during your lifetime. This is not going to provide creditor protections, generally speaking. You can pull those resources out whenever you want to. You can put them into the trust. What oftentimes will happen, though, is we'll have a client that will set up a revocable trust that when they pass away, it becomes irrevocable. And so those assets, they're titled within the trust. So they may have investment accounts. They may have their home titled there. Those assets are in a revocable trust that could be modified at any time during a client's lifetime. Once they pass away, then it's in an irrevocable trust. And that's where the creditor protections really start to come in play. So if you have an accident on I-40 and you're sued for the damages that an attorney says that you caused, then you're going to have insurance against that. But if it goes above and beyond that, then any assets that you would have in a revocable trust, they're going to be fair game to come after. But if the same thing happened and it was your son or daughter who had already received those assets into an irrevocable trust, then generally speaking, there's going to be a lot higher likelihood that they're not going to be able to come after those assets because they're technically not owned by your son or daughter. They're owned by the trust, and the trust has certain provisions of how they can distribute that to your son or daughter.
Right. Thanks for walking us through that high level of revocable, irrevocable trust. Let's talk about spendthrift provisions. What is that? How does that affect a trust?
Well, you want to make sure that there's language there. Now, a spendthrift provision is going to protect the assets. It's a clause within a trust that's really your best friend or your beneficiary's best friend, because it's going to keep both the beneficiary and their creditors from accessing trust funds directly for certain purposes. So it's basically keeping that inheritance as a safe space, in a safe space of sorts, until that they can prove that they're not going to be going to buy a pet tiger there. So it's helpful in that regard. Now, where the rubber meets the road on this oftentimes is how do you set up a provision within the trust, and how do you get the language right? And this would be an attorney doing this, not us. So an attorney getting this right, where there is a capacity to take resources out for certain things.
Right.
Sometimes this would be known as a HEMS provision, because it would be health, education, maintenance, and support. Right. Basically, there would be the categories that you could take funds out for, but it wouldn't be the pet tiger.
Right.
That's not something that you need.
Yeah, even if it's an emotional support animal.
Yeah. And hopefully you're not bringing it into Lowe's the same time that I'm going into Lowe's. Yes. Yeah, I can handle the dogs, not the pet tiger. Yeah. But there should be language there that keeps creditors from taking those resources. The challenge is it also sometimes needs to keep a beneficiary from accessing those funds in a trust as well. So you can have a trust that's set up that's an irrevocable trust, where the beneficiary is also the trustee. And there are still some creditor protections, generally speaking, on that. It can be very, very helpful. But if the beneficiary can't be trusted to raid the cookie jar, then you've got to be really careful. So you may need to have an independent trustee. You may need to have another family member, a trusted friend, or even a professional who would be a trustee who you would have to pay. And that's where things can get to be more expensive there. Again, we don't act as trustees, but there are plenty of good trustees that are out there, but they are professionals and you've got to pay them. And that sets basically a gate that professional will listen to the beneficiary's requests and make a decision on whether that's within the language of the trust document to go ahead and make that distribution. Now, the ideal situation is when you have actually a beneficiary that is going to make wise decisions and can act as his or her own trustee there, typically speaking, because that can lower the expense.
Right. Well, and I think the reality, when you choose the right trustee, we want to think not just about, we want to think about who's going to make the best decisions for that beneficiary. But we also want to really take this in a wise direction and saying, okay, how is this going to affect the relationship between those two people? If it's brother-sister, is that going to cause consternation that brother has the hold of the resources over sister? You really need to think about this. Okay, in this situation, maybe it's better to hire somebody as an outside trustee so that you're not creating additional conflict within the family. We really have to consider that as we move towards, okay, what is the right path of trustees over that sum of money. All right, so let's talk about inherited IRAs, the 10-year rule. What do we need to be aware of with all of those factors? You've kind of already touched on that idea of the 401k, the IRA may not have inherited protections from creditors. What are some other things we need to know?
Well, one of the first things that we always talk with clients about is if they have an older trust, let's just say beyond 5 years older, they may need to have their language updated to address the changes that came through with the Secure Act. So with Secure Act, you had a situation where the beneficiaries of IRA, if they're non-spousal, they have to have a full distribution typically within 10 years, unless there's some other elements that are a bit unusual there. So for most non-spousal beneficiaries, they're going to have to take out the full amount of funds within 10 years. Well, there needs to be some language within the trust that encourages the trustee or recognizes the level of distributions that will likely be necessary over that first 10 years, because typically you don't want the trust to hold those resources and not push them out because the level of taxation within a trust is far higher. So that's kind of the first thing is if we see a dated trust or an aged trust, there we want to surface that. Generally speaking, attorneys are going to know, certainly right now, that they've got to include language in there, and they've got to have a conversation with a client about, okay, how do we want these resources distributed out, because it's only a 10-year window. There are trusts that are out there that are set up certainly for folks that might have special needs, may have and may not need the level of distribution, or it may be actually harmful to have a higher level of distribution because it eliminates governmental health care or governmental benefits there. So those kind of specific situations, we've got to be really careful, work very close with an attorney to make sure that the language is appropriate and that everybody's on the same page in terms of how those distributions are going to go and what latitude a trustee might have to be able to not push those resources out to that particular person.
Right. Okay, so let's take another shift here and talk about, we're moving kind of from trust into other ways that we can encourage our beneficiaries to think about how they can protect their resources. So prenups, postnups, and awkward conversations. The reality is anytime that you have a son or daughter that is in a dating relationship that may get moved towards marriage, if they are set to receive a large sum of resources, you may need to have an awkward conversation with them about, hey, how are you considering this? You want to talk us through any of the considerations there?
Well, we hold marriage in very, very high regard on a personal level. And so I think we've got to be particularly sensitive to the worldview that a client uses as they enter these particular situations. You can certainly set up documentation, with a prenuptial agreement, with a postnuptial agreement, there's always going to be a level of awkwardness, the reality is, in these types of conversations. But you want your son, your daughter, your heir to go in eyes wide open on this. So they may look at the trade-offs, and if they've reflected on things, they may say, no, we're going in and we're going to be completely together in all of this. If something happens and the marriage falls apart, that's a risk that I'm willing to embrace. Great. If they feel a need to have some level of protections put in place, then they'll want to sit down with an estate planning attorney on that. But the reality is, receiving an inheritance of significant resources is going to be an event. And it's going to be one that there just have to be financial conversations around that. Ideally, you have a strength of relationship then that allows those conversations to be had in a really good and healthy way. But if you don't have the conversations, our experience has typically been that that doesn't improve the relationship at all. So it could put the relationship in peril from the outset, but if the relationship was going to be in peril at the outset or 3 years down the road, you might as well surface the awkward conversation and just say, hey, we're going to think about it, reflect on it, and move forward in a way that we're both comfortable with.
Right. Yeah, that's good. So Spencer, one thing that we encourage clients to do frequently is if they're wanting to pass resources along to their heirs at their passing, we'd say, hey, maybe it's an opportunity to actually pass some during your life. Why is this maybe a unique strategy, but one that can be really helpful?
Well, it gives you an opportunity to actually see how they're using the resources, the thought process behind what they're doing. Now, the reality is, if you move in that direction, and let's just say you had a significant sum, several millions of dollars that were going to be passed on to heirs, and you were a little concerned with one or more heirs there, and you say, well, I don't want to enable them, so I'm not going to make any gifts during my lifetime. Well, maybe that $10,000, $15,000, even $50,000 gift gives you an opportunity to evaluate how are they going to process this. Now, if they receive, a $30,000 gift, and within 3 months it's all been used by a vacation to Disney and an African safari and this, that, and the other, then you'll see, okay, well, was that a wise use of the resources? Maybe that's in line with what you were hoping for those resources. But if it wasn't, then it gives you some real-time feedback on how that heir is going to use those resources. Maybe you want to put resources in a trust then and have them administered in such a way that they are slower in terms of their distribution over time. That can be helpful. But generally speaking, we come back to doing more living and giving during our lifetimes. And this would be the giving side of things, to actually pass along resources earlier, because then beneficiaries can use those resources earlier. There's a lot of times that a young family might need the resources to be able to help out with education or to help out with childcare or other things that they can do when they're 35 and not 55. But the feedback loop, again, is a significant thing there too, that helps you to determine what your next steps might need to be in equipping that steward.
Yeah. Okay, so what happens if you do nothing? If you've just punted the ball long enough and said, I don't want to write the estate plan, it makes me uncomfortable, and then you get in a car crash and die. What happens then?
Well, hopefully at least you have a will put together. If you don't have anything else, then at least you've got clarity. Now, at a bare minimum, we would come back to, you need to have your beneficiary designations updated and thought through. If you and a spouse pass away, who are those resources passing on to there? So you need to have a will, ideally beneficiary designation set up. And then the next step would be, for thoughtful folks, it would be, okay, have I done this in the last couple of years? And have I considered things like a trust or other types of vehicles that might be helpful? If you've not done any of that, then the good news is you do have a will. The bad news is it's the state of Tennessee or wherever you reside. It's that state that has a will for you.
Yes.
The bad news is also that things are going to get really expensive, probably with attorneys, because going through and drafting a will and having your beneficiary accounts or beneficiaries updated on your accounts is going to be a tremendously cost-saving step rather than having this just go through and you dying intestate.
Yeah.
So we come back to, let's do the work up front. Let's pay the attorneys a small amount rather than paying them a large amount later on.
Yeah. Well, and to your point, your lawyer, your attorney, whether it is drafting a very basic estate plan or a really complex special needs trust, they're going to be your best friend and your ally throughout this entire process. And similarly, if your estate plan is very simple, it's not going to be as expensive as if you have a very complex trust that you're trying to establish. Anything else that we need to touch on in terms of lawyers, estate planning that we need to really think about before we close this episode out, Spencer?
I think we just come back to, you're going to pay them now or pay them later. You might not like the bill now, but I guarantee you it's going to be a whole lot less than it will be later. And, they will be your best friend. They'll be an expensive best friend. They will be a best friend in that. And the expense, again, is far less than the value that'll be delivered in terms of just solidifying that planning process going forward.
Okay, well, great. Well, thanks for walking us through just this idea of how do we really think through passing on resources wisely, and especially in ways that maybe protect our children and our heirs from creditors. Clients, if you have questions about this, feel free to bring them to us. And if you have questions or comments, leave them below, and we look forward to seeing you next time. Take care. If you like these financial planning videos, please share with a friend, and if you have questions, go to our website at SeriousRetirement.com. This content was provided by Retirement Planning Services. We are located in Knoxville, Tennessee. You can visit our website at SeriousRetirement.com. The information in this recording is intended for general educational and informational purposes only, and should not be construed as investment advisory, financial planning, legal, tax, or other professional advice based on your specific situation. Please consult with your professional advisor before taking any action based on its contents. Advisory services offered through Retirement Planning Services, LLC.